here that your attendance and shall be heard. I will say the Commonwealth of Massachusetts, so is now open to
SJC-10976, Parreira versus Commonwealth.
Good morning.
Good morning, Your Honor. May it please the court. This case is here on a reservation and report by a single justice. The case is from Marlborough District Court, and it involves an issue of prior jeopardy. In this case, the defendant was charged with breaking and entering with intent to commit a misdemeanor and assault on Caroline Marquez. He elected to go to trial. Before the trial, the prosecutor told the judge that a necessary and essential witness, the alleged victim, was not in court. In fact, she told the judge that she never spoke to that person, that person never apparently returned any of her calls. She indicated that she wanted to get a bench warrant, but the judge told her that since she actually didn't serve any subpoena on this witness, she couldn't issue a bench warrant. In any event, the Commonwealth announced ready for trial. And
They did have other witnesses who were ready to proceed,
yes,
didn't they?
there was a witness.
Well, there were 3 witnesses, weren't there?
Well, there was a civilian who was.
There were three
yes,
witnesses,
yes.
weren't there?
There
Yes.
were 2 police officers who after, I don't know if I need to get into deeply in the facts, but the only recipient witness actually was the Mr. Albino, who was in the apartment, but he did not actually testify to any assault that he observed or heard.
Well, did he testify that the defendant had sort of pushed
Yes.
the victim or the woman Ms. Marquez into the bathroom?
No, he said that he didn't use the word push, that I think he used the
Escorted her into the bathroom?
yeah, something like that.
And he also testified that the defendant pushed him out of the bedroom.
Yeah, he said that he
Is that an assault?
Well, it could be, except that the record that I then provided the judge on the motion for new trial indicated that there was absolutely nothing in the police report about any threats towards Mr. Albino or any assault towards him. And the defense counsel, as well as the defendant, went on the assumption, and that was the assumption, that the Commonwealth never challenged actual motion for new trial. They said, no, the assault was on Caroline. So it would be unfair to then say, but that's really what but since we don't have her, we're going to go on with something else. And I also attached the police report that doesn't indicate that the defendant made any threats towards Mr. Albino or that she assaulted him. So could you make out a case? You probably could make out a case, but I think it would be extremely unfair to do so. And the Commonwealth on the motion, the hearing on the motion, said, no, that's not what we're going under. So,
is your main point that, or does your prevailing depend on our being able to conclude that the judge did this because he was seeking to forestall a not guilty verdict?
Well, the Oregon versus Kennedy says that just any kind of overreaching is not going to do. And I would say that in the opinion, the court's opinion, in that case, I believe Justice Rehnquist makes a very good point that it would not benefit the defendants as a class if during a trial there is a motion for mistrial because of, usually it's a prosecutors of a Ricci.
But this is what you say is forcing a plea, right?
I'm saying that it's clear from the record when the defense counsel says to the judge, the defendant is going to take the stand. He makes a motion for a required finding. He says he went there because he wanted to talk to her. He just wanted to talk to her.
Right, but I guess I'm...
Yes,
I mean,
it does.
Is the point
It
that
does.
it does require us to conclude
it
that the
does.
judge was doing this because he foresaw there was going to be a not guilty verdict?
Well, I don't know if anybody can
No,
foresee
but he
anything,
was
but-
doing it to forestall a
Well,
not guilty verdict. I mean,
yes,
that's what Tateo
yes,
says, right?
I'm sorry?
That's the footnote in Tateo, if I'm saying
Well, yeah, there's a footnote in, I'm not sure how to pronounce the case, Tateo, I think it says. But yes, it says that would be the exception. Tateo is generally criticized because the Tateo says, and in Tateo, there was no indication whatsoever that the defendant is getting off. But there was a statement at the court that he's going to get a more severe penalty. He then went to trial and was convicted after his plea was vacated. But the basis for concluding that that is just a regular trial error by the judge, it's very difficult to equate a clearly statement by a trial judge. If you do not plead, you're going to prison.
But you get a new trial, as opposed to you cannot be tried again. I mean, isn't that the difference?
Yes, there is a difference, absolutely. According to Oregon versus Kennedy, you have to have some indication, some intimation on the record. The problem I see is that who's going to make that determination?
So what do you say we should look at in this case to make that determination?
Well, the only thing that can be done is to view it as Justice Powell suggested in concurrence to Oregon versus Kennedy, that it's an objective standard because we can't put the judge on a stand and try to show that that's the reason.
So what is the objective standard applied here? Tell us.
The objective standard is the indication on the record that the judge did it for absolutely no legitimate reason, and it's never legitimate for a judge to do what the judge did here.
But there's a difference between no legitimate reason and bad faith.
Well, yes, there is.
How do you get to the what's in here that you tell us gets us to bad faith?
Well, the judge knew that the Commonwealth didn't have what they claim was an essential and necessary witness. And everyone would agree that that person was necessary.
Well, there's another way to look at this, too, and that's that the judge, perhaps being impatient, thought that this was maybe not a case worth trying. It was open and shut, and let's see if we can bring this to an amicable resolution.
Well, I would disagree that anything that requires a coercion, anything in court, how is it amicable? It's not appropriate. It's
So he was
completely...
trying to keep your client out of jail.
Well, he didn't know anything about this defendant. He didn't hear what he had to say. Obviously, when you stop the trial after the prosecution presented case, supposedly they have some evidence against the defendant. I mean, otherwise the case wouldn't be there at all. So that's true in every case. But the conduct must be condemned, what the judge did here. He didn't hear the defendant's case. He didn't know anything about the defendant. And the case, the Commonwealth claims that even without this essential and necessary witness was, in their words, overwhelming. And that's really the reason I mean, it's ludicrous to call this case overwhelming because we don't even have an assault there.
But the defense counsel says, maybe he's not going to get off on the A and B, but it looks like he's going to get hooked on the assault unless something strange happens. That's the defense counsel saying that.
I'm not sure that that's actually what he said.
But it's what the
It
transcript
looks that
says.
way on the record. I agree. I mean, it does. I don't understand why he would say that because he himself says to the judge he only wanted to talk to her. But I don't see an assault objectively on this evidence.
Well, she was terrified. She was hiding under the bed covers. It was 5 o'clock in the morning. He opens a closed window in an apartment, climbs through, and demands to talk to her.
Well, I mean, I think that it still requires guesswork. This is an embarrassing situation. She broke up with the defendant that night, few hours before. And now, and we don't know who broke up with whom, but is it wise what he did? Well, I mean, I wouldn't say it's wise. And nowadays, you're going to be labeled a stalker. You're going to be, no matter what. But who hasn't been in the situation, breaking up with somebody and then wanting to talk to them? And they were friends. Albino, that was a friend of his for at least a year. And he had some reason to believe that she may be dead because he was her friend apparently too. So to say that, we don't actually need to know whether there was an attempted assault or was it a threatened assault, which part of the assault was actually, what did he actually do? But we can just, because she was terrified, maybe she was just embarrassed. Who knows why? She was apparently staying there, maybe for comfort. Maybe she was just horrified about the whole situation because it was likely to be something that, those are kids, 18, 19 years old, everyone in school or their friends would know about it. Who knows why she was...
Now, there was a series of telephone calls by the defendant to her as well, weren't there? No phone calls?
Nothing like that. No, that was... He just went to talk to her, and apparently this is the same apartment complex where Albino and Ms. Marquez lived. So it would not be sort of like she wasn't home at 5 o'clock. Maybe he was worried about her. Who knows? Until you hear from him, and there is an affidavit, and that from her that in a motion for new trial that he never assaulted her.
But you've heard from Albino, haven't you?
I'm sorry?
I mean, didn't he testify?
I mean, I think that testimony was that she was scared and crying, and that
No, she was...
and that he physically moved her
Yeah,
into the bathroom.
that
And those were the exact. I think those are the words from the transcript. Physically moved her.
Well, it doesn't, I mean, if you're escorting someone, do they want to talk? If you said to somebody, let's talk and let's go in there, okay, I don't know. That's an assault. I mean,
Yeah, I'm trying to figure out what this objective standard is that you suggest we should use. Is it that the evidence would be insufficient as a matter of law, or is there something else that you say would be the objective standard that we should apply?
Well, those are two different grounds that it would be double jeopardy. If the court agrees,
Okay,
if the court agrees that there is no sufficient evidence, that's one ground.
Right. Okay. So I gather then you're saying that the objective standard can still prevail, or that you can prevail on that, even if there is sufficient evidence as a matter of law.
Well, the Oregon versus Kennedy sets out the standard that you have to have an intent to cause a mistrial.
I understand. And then and you say that we should apply an objective standard to that because we don't want the judge to be explaining what he or she did. And I'm just trying to figure out what that objective standard should be.
That if there is, as was actually mentioned at Tateo in the footnote, if there is an intimation that may be the reason why the judge coerced, threatened the defendant with prison, that would, because we don't actually, as a practical matter, have another way. The standard that usually is applied to prosecutors for their overreaching, at least the trial judge could have a hearing, and then it's up to the trial judge to decide what was the intent of the prosecutor, that the prosecutor intend to cause a mistrial because maybe all of a sudden he finds out that he doesn't have some witness, the case is not going well, so he wants to have another bite at that case. We have at least a judge, even the majority opinion, the court's opinion in Oregon versus Kennedy acknowledges that this is not an easy standard to use because it requires a judge to make findings against prosecutors regarding their intent. But who's to make a finding against the judge if the judge is the one that overreached? So it presents a real problem to say that it has to be shown as a subjective intent to cause that.
Counsel, we'll have to leave it there.
Thank you.
Your time is up. Thank you.
May it please the Court, my name is Casey Sylvia, and I'm an Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth. Your Honors, the motion to dismiss in this case was properly denied, and retrial should be permitted because the record demonstrates objectively that the judge did not act in bad faith or with the intent to forestall an acquittal.
Why do you say that? I mean, the judge knew that the Commonwealth had been unable to call the critical witness, at least on the assault and the assault and battery, which seems to be what this whole case turned on. I don't think it was much of a question that was a breaking and entering.
Yes, Your Honor.
So he knew that. He knew the defendant was about to get on the stand, and why couldn't one read that record to suggest the judge wanted to help the Commonwealth out here by putting a little pressure on the defendant? It's jail or not, depending on whether you plead guilty right now.
Your Honor, there was a recipient witness that testified he was there for the entirety of the incident, so I don't think you need the actual victim to get on the stand, the victim of the assault, because of the fact that the recipient witness was there for the entirety of the incident. He's there from the point at which...
So did he testify that he observed the defendant here either assault in some way the victim?
Yes, Your Honor. He testified that first the defendant comes in through the window. He's very angry. He tells him to leave, so the breaking and entering. And at that point, he appears to be looking for something. He searches through the entire apartment looking for Ms. Marquez. And when he finally finds her, she's hiding under the covers, crying. Obviously, I think the inference is that she's fearful of the defendant and the fact that he's broken into the house and is searching the entire house for her. He's angry at that point, and she's in fear. At that point, he locks the bedroom door, locks himself in with the victim, and is yelling at her. When the bedroom door is opened, he physically moves her into the bathroom, and that's the exact testimony, is that he physically moves her into the bathroom and continues, I guess, haranguing her in the bathroom. When they come out of the bathroom, he then threatens to kill Mr. Albino. And Mr. Albino...
Is that what you're relying on, or is that just part of the context?
That's just part of the context, Your Honor. And Mr. Albino's testimony is that essentially throughout the entire incident, he's very angry and he's yelling, and Ms. Marquez is afraid, she's crying, and she's hiding under the blankets. And in fact, when the police arrive, she's still hiding under the blankets, or well, she's still cowering under the blankets and crying and very upset. And so I think it's more than a reasonable inference in those circumstances that the defendant committed an assault by either of the two theories, either an attempted battery. In fact, I think there was a completed battery.
So based on that, based on what you say the evidence was, the judge wasn't trying to coerce a plea to avoid an acquittal, but simply to resolve a case which, in his view, was pretty strong on the Commonwealth side?
Exactly, Your Honor. I think that's exactly what the circumstance is. I'm not saying that what the judge did was ideal, maybe in the circumstances.
Well,
but
he vacated the plea later
Right.
on, so obviously, in retrospect, he didn't think it was so ideal either.
Exactly, Your Honor. I think that there were some things that were said that were probably better left unsaid, but I think when it comes down to it, if anything, when you look at the record, objectively speaking, it looks like he was probably trying to help the defendant out at that point, even though there were some things that were said that probably shouldn't have been. And like you said, I think the judge recognized that, and that's why he vacated the plea. But I really don't think there's any evidence on this record that there was about to be an acquittal, and that's why the judge acted in the way that he did. And in fact, I think everybody agreed at that point, including defense counsel, that the trial was almost certainly going to end in a conviction.
Did the I guess two factual questions. Did the judge say anything about the requirement of, I don't remember the statute, but whatever it is that says if you have a crime under 265, jail unless you make findings?
He did say that. He said that, frankly, I think that he had a little bit of a misunderstanding as to that statute, because he seemed to think if the defendant pled at that point that he would not have to make findings as to why he was not putting him in prison. Having said that, 265, there's no such requirement under the statute. If the defendant's convicted of a crime under 265, findings have to be made to justify not putting him in jail. But he did make reference to that. He said that if he's hooked on the assault, that he didn't see any reason at that point why he would not impose jail time, but that if he pled at that point, that he would go along with the Commonwealth's recommendation, which was a suspended sentence. And I also do just want to point out that the Commonwealth's recommendation would have stayed the same regardless of whether the defendant was convicted after trial. So there's no suggestion of any sort of prosecutorial misconduct in these circumstances.
And the second factual question is, when you said that the recipient witness was testifying to a lot of yelling and haranguing, was there any content? He didn't testify to any content?
No, he didn't. And he was actually asked about that, and he said that he couldn't recall any specifics, but I think he said it was just continuous yelling or continuous shouting. But he was asked that question, and he couldn't give any specifics as to what was being said.
Was there any return shouting from the victim?
There wasn't any testimony as to whether there was return shouting.
But he heard her crying? Is that?
Yes. He heard her crying, and I think he testified she was very scared.
The defendant was not charged with threats towards Mr. Albino.
No, he was not, Your Honor. I'm sorry.
Was the judge aware that the prosecutor had not planned to be offering time if he were to be convicted?
Yes, Your Honor. The prosecutor made that clear up front, that one way or another the recommendation was going to stay the same.
So when the judge said, I have to impose time, he recognized that that was going to be above and beyond what the prosecutor was going to recommend to him, even if he were convicted at trial.
Yes, Your Honor.
And what do we make of that? I mean, that's a pretty unusual thing for a judge to say. What intent do we infer from that?
I think it's, it is unusual to exceed the prosecutor's recommendation, but it's not unheard of, and I don't think that there's anything inherently improper about it. The judge's comment on the evidence and on the charges before him was that he thought it was egregious based on what he'd heard. I don't think that's an unreasonable thing to say. He mentioned that the defendant could have been charged with home invasion. I think he also probably could have been charged with kidnapping. And so while it is unusual, I don't think that there's anything improper about saying that if he's hooked on this, based on what I've heard so far, I'm going to impose jail time based on that. I think that's within his discretion, even if it is unusual.
Do you have any thoughts about what the objective standard should be for whether one is looking at determining if there is an effort to goad or to forestall a defense verdict?
I think it's whether or not, looking at the record, whether or not a reasonable person would believe that the judge acted in bad faith and in order to avoid a likely acquittal. And when I looked at Choi, which obviously is one of the major cases on double jeopardy, Choi defined bad faith as conduct that affords prosecution a more favorable opportunity to convict. And so I think what the standard should be based both on Tateo, Kennedy, and this court's jurisprudence on double jeopardy, and specifically in Choi, it should be whether or not there's objective evidence that a reasonable person would believe that the judge was acting in such a way to afford the prosecution a more favorable opportunity to convict, or put differently, to forestall a likely acquittal. And in this case, I also just want to point out, when it comes to the motion to dismiss, it was not the trial judge, who's the same judge as the plea judge, obviously. It was not the plea judge that decided the motion to dismiss. It was Justice Arasinger. And I think that may be appropriate in circumstances like this to have a different judge decide that motion to dismiss. And again, I just want to point out that the standard that the Commonwealth is proposing, it's in line with the federal holdings, it's in line with Tateo, it's in line with Kennedy, it's in line with this court's holding in Choi. And I also just want to point out that with regards to federal jurisprudence on double jeopardy, this court has consistently held that the Massachusetts common law is coextensive with the federal protection against double jeopardy that's enshrined in the U.S. Constitution. And I also want to point out that this, what the Commonwealth is proposing in terms of the standard would also be in line with what a number of other states and the Second Circuit have found the standard should be for goading or provoking a mistrial. Maryland, Connecticut, Wisconsin, New Hampshire, Texas, and the Second Circuit have all held that the goading must arise from a fear of acquittal. And so I think that what the Commonwealth is proposing in terms of the standard would be in line with a number of other states and would be in line with the federal jurisprudence on this topic and would also be in line with this court's holdings in Choi. I think it would be a natural extension of the holding in Choi, the definition of what bad faith conduct has to entail with regards to a judge. And I also do just want to point out that, as has been pointed out in Choi and in a number of this court's cases, is that allegations of judicial impropriety are not things that should be, they're not accusations that should be made casually. And I think that's exactly what's happening here. I think that there's some sort of suggestion that because of the fact that there's an error, simply by virtue of the fact that there's some type of error, and that the process is defective in some manner, that therefore there had to have been bad faith, that therefore this had to have been vindictive. And I just don't think that there's any objective evidence to suggest that that was the case.
You suggest, or you argue, that it wouldn't be appropriate to have a different standard when a judge puts pressure on a defendant to plead during trial than the standard that applies if a judge puts improper pressure on a defendant to plead before trial. But isn't there a difference? Because the fact is the defendant has participated in picking a jury of his choice. He has a right to have that jury decide the case. And so the pressure in trial seems to be much more serious problem for the defendant than before trial, doesn't it?
Your Honor, I do agree with that. I was giving that some thought over the weekend, and I do agree with the fact that there are different pressures at play once you've already selected the jury and you've been put in jeopardy. I actually think it might be more akin to the circumstance where there's an involuntary waiver of the right to counsel, for instance, which would be a structural error, and the trial's already commenced, the defendant has been put in jeopardy, and it's sent back for a retrial if it's reversed at that point. So I actually think it might be more akin to that circumstance. The Supreme Court in Tateo suggested that it was similar to the circumstance before trial where there's a coerced plea, but upon further reflection, I think it's actually more analogous to the circumstance that I just suggested with regards to an involuntary waiver of the right to counsel. Your Honors, if there are no further questions, I would simply ask that the Court affirm the denial of motion to dismiss and send the case back for retrial, as this Court did in the Letters case, which we cite in our brief. And if there are no further questions to the panel, I'll rest on my brief. Thank you.
Thank you, counsel.